Hello, everyone. Welcome to the Ottawa Heart Institute Foundation's first ever interactive webinar. My name is Lianne Laing, and I'm the new Executive Director of the Foundation, and I'm really excited to be hosting this event tonight. As the former host of CTV Morning Live, I'm looking forward to being back asking the questions that I hope many of you joining us tonight would want to ask. So we have an amazing panel for you on the topics of wills and estates, as well as planned and charitable giving, with an opportunity for all of you to get in on the conversation. We are eager to hear from you, and we will have polls and questions for you, which we hope will help direct the conversation as well. So before I kind of introduce the panel, let me first ask you, do you have a will? Simple question, yes or no. And please take a moment. That question will have popped up on your screen, and I'd love to be able to get your answers and really kind of know exactly what we're dealing with tonight. We have so much to get to tonight, so I'd like to take the opportunity to introduce you to our speakers. We have Heather Austin-Skaret, who's joining us, an estate lawyer and partner with Mann Lawyers. She also did a fantastic job for us on CTV Morning Live on Friday, if you were able to catch that segment. We have my colleague and the Director of Planned and Legacy Giving of the Foundation, Selva Trebert-Sharman. Now, I have to say, I look around her office. It is filled with binders and filing systems and what looks like endless paperwork, but I am amazed by her passion for this line of work, where the conversations and language is so sensitive, very personal, and also life-changing. She has a wonderful sense of how to help families navigate through all of this. We also have Paul and Marilyn Koch. Now, Paul is a past patient of the Heart Institute, and he's pretty quick to point out that he wouldn't be here without us and wouldn't be here joining all of us tonight had it not been for the Heart Institute. And they are also incredibly generous donors. So Paul and Marilyn have left a legacy gift for the Institute in their will, and we hope they would share their story with you tonight. So I'm gonna wait a couple seconds and see if we have an answer to that poll. So something you might wanna think about. It was a simple question. Do you have a will, yes or no? And with that being said, I'll come to you, Heather, as to why this topic is so essential, is so important to have. So Heather, take it away.
Well, Lianne, thank you for the introduction. From my perspective, a will is absolutely crucial to have. It is the kindest thing one can do for your family. It leaves a set of instructions about what to do, how to go about it, and it hopefully will alleviate some unnecessary family fights. Leaving your estate without a plan leaves the family trying to figure out who to approach, where to start, what to do. It's a horrible situation to be in when they're already grieving.
It's a great start to the conversation, and I appreciate that, Heather. And we're going to come back, Heather, and really narrow it down. And interesting, because we've got a lot of people who are educated tonight, and I think are just looking to expand on it, because coming off of that poll, 74% of you are saying that yes, you're on top of things, you have a will. 24% of you are saying no, not quite. And so we'll get into some of those other details. And then Selva, I'd want to come to you just because you're usually on the other end of these conversations with potential donors. And so what's it like for you to kind of be on that side, understanding what it is that people are looking to do?
Well, it gives us the opportunity to really see what they envision in their legacy plan, if they're looking to leave a gift to the Heart Institute. And it's our opportunity to help them with that, to show them what sort of impact their gift will have. You know, from work experience, I've seen situations where we've had about 3 different estates where there hasn't been a clear, or there's been a clear will, thank goodness, but there's been, the will's been, for example, contested. It's been, fortunately, because we've had a will, they've been able to see, they've been able to basically get the individual's wishes across, everything has worked out the way that they would have hoped it's worked out. We're actually working through one now. From a personal perspective, I mean, I had an uncle who passed away without a will, and it made things quite difficult. He had dependents, and passing on, you know, what he wanted to pass on to those dependents made it more difficult without the will.
We're going to come back because I think there's a lot more emotion when it comes to some of the conversations that we have there. And then I want to come to Paul and Marilyn, because Paul, I do know, because we had a chat about this, your dad was an insurance agent. So you knew very early on, I think you said you were like 18 when you started to kind of consider this, but when was the conversation between you and Marilyn? When did you start knowing that you needed to prepare that will? What prompted you, the two of you, to do this?
Well, specifically, I can't remember exactly when that happened, but I do know that shortly after we were married, we had our first will prepared. And I think my father did it. At that stage, it's a pretty simple will. Your net worth isn't anything. And so you don't have to worry about too much. But then as the children were born and so on, we would make changes as time went on.
Can I ask when the decision was in kind of, I know that you have updated a number of different times. When was it that you decided within the will that you knew a charitable donation was something you wanted to do?
2014 actually was when we had a major job done on our wills. And it was at that time that we included the Heart Institute and a couple universities and one other charity in our wills.
Okay, so let's go through some of the details because we're starting to see a lot of questions coming in, and I know that there's a part of this that a lot of people are looking at. So Heather, a couple of things, and I'm going to get to some of the questions, but what's the difference between your estate and your will? Is there a difference there?
There is. The estate is comprised of many things apart from the will. So you may have life insurance, or more commonly registered plans, so a tax-free savings account, or a Rrsp, a Rrif, a LIRA. You may hold real property. Each of those assets has a potential to be passed directly to a beneficiary as opposed to flowing through the will. So when people talk about an estate plan, we talk about all of those things as well as a will and your powers of attorney.
So when you're going through this, should there be a different focus depending on your age?
Absolutely. Depending on your age and depending on what your assets are. So depending, again, Paul mentioned children and marriage. So wills are very much living documents. Your estate plan should grow and contract with you, depending on how your life develops and what your obligations are. You will have to update accordingly. And not to mention, laws change sometimes. So we've seen major tax changes in the last few years. And so updating your plan gives you the opportunity to have it as current as possible to benefit those people and charities you wish to benefit in the most tax efficient way possible.
Can I ask you that? Because those questions just came in. We had Annalisa asking, how do I need to start? How old do I need to be to start thinking about estate planning? And then we had another question come in saying, please talk about the tax implications of charitable giving in one's will. So what are, if you don't mind me asking right now, some of those tax implications?
Sure. So as a starting point, when you die, the government will deem you to have disposed of all of your assets at fair market value. So dying is a taxable event. And so if you have a capital asset within your estate, the starting point is that there will be tax on any gain. However, there are some tax provisions that allow you to defer the gain, depending on who you might have as a beneficiary. So the most common example would be for an Rrsp to be designated to one's spouse. And all things being equal, if the spouse is designated, the asset will roll from the deceased spouse's Rrsp plan to the surviving spouse's Rrsp plan, thus deferring the tax until the surviving spouse withdraws the money or dies, and then it would be taxed. If you had designated a child, an adult child, you would not have the same result. So the adult child would receive the amount of the plan because they're the designated beneficiary, but the estate would then have to pay the tax. The amount of the plan would be brought into income in the year of death.
Okay.
That's a lot of information.
There's a lot of information there, and I think there's a lot of things that people are asking, and I guess a lot of it dependent on timing, what's at stake, what the ownership is like. So these are things that that speaking to someone who knows how to follow through this, it'll all fall into different categories.
It will. The most common problems we see are piecemeal planning. So you take a plan and you can have a designated beneficiary on it, or you can own an asset and have a joint account with a different beneficiary, and you've done this piecemeal planning. But when the executor tries to deal with the estate at the end of the day, it can become very problematic. So a holistic view, which is what I'm assuming Selva would talk about with a client, a holistic view of one's estate is the approach that I would recommend in estate planning.
Selva is having the conversation with a lot of people. And so Selva, when you have people that are designated, they understand the components to their will. What happens when they do make that decision to add in the charitable giving? At what point is it realizing that they're leaving a major impact with that legacy gift?
Well, that's a conversation that we're happy that I'm glad that I get to have with them. I mean, including a charity in your will is something that's extremely personal. So the fact that they've considered doing something like that in such a personal way, the same place that they include their family members, their loved ones, it's something that really honors us. So I find it's a very intimate conversation. So it's a great opportunity for us to sit down and see where is it that you'd like to direct your charitable giving. Is there a particular area that's important to you for a particular reason? So it gives us the opportunity to have that conversation. And really, when it comes to the type of gifts, we talk about that with our donors as well, the different types of gifts that they can make, whether it be life insurance, retirement plans, as Heather mentioned, but we always refer them back to the professional advisor, to the Heathers of the world, the lawyers and the financial advisors as well, because while we can sort of guide them as to what sorts of gifts we accept and what might be a good fit based on what they share with us, really it's that professional advisor that's going to have the knowledge and that relationship with them to know what would be best for them.
So I have a feeling that Paul and Marilyn kind of knew what felt best for them. And I think because it was so profound to them, and of course, with Paul already being a patient with the Heart Institute, Paul, for you, what was that discussion like with the family to understand that part of the estate and the will was that you wanted to leave legacy gifts? What was that conversation like between the two of you?
I should let Marilyn answer that. I think we just agreed in principle that it was something we should be doing. And we've been very fortunate in life to have good jobs and good education. And so we only have 2 children. So we want to make sure that other relatives and some charities benefit.
Did you have that discussion with the children? Were they part of the conversation, or to understand where your wishes were, or what you had planned when kind of always updating your will?
We didn't really ask their opinion. We just did it. And our older daughter is our executor. Well, Marilyn's my executor and I'm her executor. But the older daughter, who's a chartered accountant, is the brains of the family.
I love that you're saying that. I wanted to ask another poll question because we're starting to get some questions that are coming in, and I think sometimes marriage and divorce comes into play. So let's see what you guys are thinking, because the questions have come in, and I know that we were planning on talking about this with Heather, but does marriage revoke a will? So a poll question, what are your thoughts? Yes and no. The other poll question was going to be, does divorce revoke a will? That question, yes or no. So those poll questions are coming in. So we'll see what you thought. You can take a second to be able to look through and to think that through. Does marriage revoke a will? Yes or no. Does divorce revoke a will? Yes or no. And so with that being said, Heather, can I come to you and maybe be able to point out where we're going with this?
Absolutely. So we discussed this ever so briefly on Friday morning as well. And I hope it didn't offend anybody, but yes, the way the Family Law Act works, a marriage will revoke a will that was made prior to the date of the marriage, unless the will was made in contemplation of marriage. And it's not enough to say that this will that I have drafted, I made this in contemplation of marriage. The language actually shows up in the will, in the written document itself. And the reason a marriage will cause a will to become invalid is because the plan within the Family Law Act is a complete regime for the disposition of assets as between spouses on the end of a marriage. And the end of a marriage happens when there's a death as well as when there's a divorce. On the other hand, for those of you who answered the poll question on divorce, a divorce does not revoke a valid will, assuming the will was made after the marriage. The legislation provides that the will is read as if the spouse from whom you are now divorced predeceased you. So the will remains valid, but the gifts to the spouse are out, and the appointment of the spouse as estate trustee is out.
That's interesting because I'm looking at the response, and 50% and 46% didn't know the right answer. So it is quite confusing. And so that's something that I think you really need to consider. 46% of you said yes, 50% of you said no. And then we had a question that came in from Joanna, and she asked, does the surviving spouse have to have an RSP or an RRIF to benefit from the deceased spouse's RSP to benefit without paying the tax? Does that make sense? Do you need me to reread that one? That came in from Joanna.
Yeah. Say that again?
Sure. Does the surviving spouse have to have an RSP or an RRIF from the deceased spouses to benefit from the deceased spouse's RRSP to benefit without having to pay tax?
No, it can roll into a new plan. So the surviving spouse doesn't have to have a plan in place. They could open one and roll the deceased spouse's plan into their new plan, if that's what I understand the question to be. So generally speaking, as long as you are spouses of one another, which for that purpose would include common law spouses, then the deceased, as long as the surviving spouse was the designated beneficiary on the deceased spouse's plan, then the deceased spouse's plan, it's almost like a tongue twister, could roll into the plan of the surviving spouse, which could be a created new plan if one wasn't in existence.
Okay. Does that have to be pointed out? You were talking about the plan and the will. So what happens if that's not in any documentation?
So it would have to be a designated beneficiary on the registered plan itself, which should happen with the financial advisor at the institution where the plan was taken out. What we have seen, which is problematic, there's a lot of online planning that can happen. And sometimes we've seen this at least once cause some problems for one of our clients where they moved their registered plan from one institution to another institution and didn't actually meet with a financial advisor at the new institution. And the switching of the plan dropped the designation of the beneficiary on the plan. And so that person in their estate planning assumed they still had a designated beneficiary. They did not. The beneficiary didn't get the money from the plan, and the asset no longer having a designated beneficiary on it fell inside of the will into the residue of the estate. It goes back to my comments about piecemeal planning.
Absolutely. And Joanna says, thank you. That was my question. So we answered the question. So Joanna, and of course, for everyone, I'm seeing some of the questions coming in. So if you have an exact question, this is why we wanted to have this interactive component to this webinar, is to be able to answer those questions exactly how you sent them in. So we are getting to those. Selva, I do want to come back to you because you're having these conversations and you see in working with legacy giving and planned giving, why it has been so important that it's been designated, because there have been a couple of, there are times when you want to be able to have that conversation with the family or to see things come through, and it's not always necessarily done the right way. And so you've had a couple of times when it could be contested.
Yeah, well, in the cases where I said, or I mentioned that we'd seen contested, it's really the will was contested by, in both cases, it was family members, not necessarily the gift to the Heart Institute. But why it is important that it is clear is for that reason, if they are giving a gift to the Heart Institute, so that we are making sure that we're respecting their wishes and it's going where they'd like it to go. And it's nice for us to be able to go back to the family then and show them as well after the fact, you know, what sort of impact it had to bring them in, you know, and show them this, give them a more tangible vision of what they were able to do for the Heart Institute. And the families love that. Like they really appreciate that. It's, you know, when individuals choose to leave a gift to any charity in their will, really it's an extension of their lifetime giving. They're supporting because that charity resonates with them, because maybe their life was saved, like in the case of the Heart Institute, or they had a family member whose life was saved. So really the legacy gift being an extension of their giving, and their family being able to see that after the fact is a further extension as well. So
So I was saying, you know, I've only been there a couple of months, but I'm learning a lot every day in the offices of the foundation and learning what it is that everyone does. And there really is that emotional impact. And so I'm learning about having names, you know, your naming of certain things and plaques. There's really a way to be able to commemorate someone so that they really do, and that family sees the impact and the legacy made towards an organization. And sometimes there's a lot of sadness and sorrow, but sometimes there's this positive, wonderful look ahead as to what this legacy is doing and how it's continually having an impact on the community for so many years to come. And you see that.
Yeah, we definitely see that. We have individuals that come back and they'll want to tell the story too. So we've been fortunate that those individuals have allowed us to share their stories, you know, and some of it, whether it be our newsletter, on our website, or CTV. You've seen some as well, just because it is, I think it, to some degree, I mean, it provides a level of, I don't want to say closure, but kind of a connection, you know, an extended connection to the individual that they've lost.
So the connection, and I want to be able to connect Paul and Marilyn back into the conversation right now. And to ask you, I know that we've kind of talked about life changes and certain things, but how many times would you say have the conversations continually shifted, that you've updated and you've made changes and you've added things to the will as the years have gone on?
Wow, that's a tough question. We've been married for 58 years, so, but I think when we first got married, and then when the children were born, and then probably a couple times in between, and then when we did it in 2014. I think one of the things that people should keep in mind is, if they do live a long life and they're in reasonably good shape, because of investments, they could end up leaving very large estates. Not that ours is all that huge, but one of the things that you could put into your will, which we have done, is once specific bequests have been given, then the residue of the estate gets divided into a number of parts. And in our case, one of those parts goes to the Ottawa Heart Institute. And who knows what that'll be worth. But over and above a specific amount, which the Heart Institute will get, they could get significantly more. Who knows?
You know, there's one thing to keep things pretty private, but what was the decision to actually let the Heart Institute know that you actually had left this in your will? Like, why did you have that conversation in the first place? You know, oftentimes the family will sit down and then things come out and your interests come out, but you actually went ahead and connected with and contacted the organization to actually let them know. What was the decision, and what was your why for that?
Well, we had been donating annually to the Heart Institute for a few years, and then I had the heart attack, and they saved my life. And it was time at that point that I think that was in 2009. I had the heart attack, and we updated the wills in 2014. So that was when we decided to put the Heart Institute in, and I informed the Heart Institute and the universities and so on of what we had done.
Well, it's definitely something, and I know, having been in the offices now, when you get a call like that, it really is quite special. And then you realize there's usually a story and a reason behind it. So that definitely comes in. And I sense from you just the passion and the interest that you have for the cause and for the charity. A lot of people are kind of dealing with so many different things and are at different stages. And so I want to come back to a couple more of the technical things, Heather, because I think there are continuous questions of tax benefits. Where are you going to get the best tax advantage? So can I come back to you, and what type of a gift actually has the best tax advantage in doing some of these changes or putting this into the will?
That is too specific, perhaps. I'm not a tax lawyer.
Okay,
I
right.
can tell you that making a charitable bequest in one's will provide a taxable receipt that can be used in conjunction, usually best working with the estate trustee and the accountant, to see how best to apply the charitable receipt to maximize the tax savings within the estate. So one of the really interesting techniques that's out there still and has been around for a while is, if you have a publicly traded stock, for instance, that has accrued capital gains on it, If you leave the stock in kind to the charity, then the estate has the benefit of an exemption, if you will, for the capital gain that would otherwise be deemed to have been received on the stock. Plus, it gets to use 100% of the charitable receipt in whichever tax year within limitations that can be applied to reduce the overall tax. So that's a double benefit, if you will, to the estate. You wipe out the gain and you get the taxable receipt for the charitable gift. That's a very effective tool. And so we will see some clients will, as Paul was discussing, leave a specific bequest, which can be a cash amount or a particular asset in kind. That's usually done in conjunction with the charity to make sure it's a gift they're able to accept. And then you have the benefit. So you can actually maximize wealth within the estate while satisfying your philanthropic intent and benefiting all your beneficiaries. It's a win-win.
It's a win-win. I'm thinking of the win-win when someone actually has a chance to be able to enjoy the lake and the cottage. And so I saw a question that came in from Nancy, and I know not to get too direct because, you know, a lot of these are all different, but it was a property question. And so what was the best way to leave a seasonal property to your children? Does that fall into place? Is this something that gets more complicated? Nancy, I saw the question come in, so I'm putting it out there.
I love cottage questions. There is no right way and no wrong way to do this unless everybody's unhappy about it. So the cottage always draws a huge amount of discussion, and there are so many ways to deal with it that the best thing I can say is have the conversation. So many people that I run into, they actually don't want to or are unable or feel that it's inappropriate to talk to the kids about it. I've had one family where it turns out the kids, none of them wanted the cottage, but there was so much angst around the discussion. If we could just have the discussion, then we can figure out what is the best way to deal with it. It's a capital asset, generally speaking. There will be a capital gain on it. Are the beneficiaries going to be resident where they're going to be able to use it? Are some of them non-residents? Are they not cottage people? Is one kid always going to be the one fixing the roof, putting in the dock, taking out the dock, putting in the water, fixing everything up, and everybody else goes up and just wants to enjoy? It can cause a lot of problems. Sometimes funding the capital gain just on death alone causes the sale of the cottage because there's not sufficient cash within the estate to pay the gain. So it takes some special planning. If it is going to be kept as a family compound for many years to come, it needs some special planning around it.
I appreciate that. Okay, hopefully we got that question in. And then I just, so I had a couple on my screen right now, and then I just lost them. So hold on one second. Oh, this came in from Jacques, and I'm not sure. I think this would be you. Does having a joint bank account between spouses automatically mean there are rights of survivorship?
That's a very good question. Generally speaking, yes. In Ontario, between spouses, a joint account or property that's held by spouses as joint tenants implies rights of survivorship. That is not the case if it's held with an adult child.
It changes if it's an adult child, not so much for a spouse.
Yeah.
I know we're getting a little technical, but I wanted to get to the question. I also have another one. This is coming from John, and I think, Selva, you might be best for this one. Do we accept Canadian common shares? If yes, how do you go about it? And what are the tax benefits for the donor?
Do we accept Canadian common shares?
Yeah.
Yes. So yes, the short answer is yes. The tax, I think it's, they're pretty much in line with what Heather was speaking about earlier. And essentially the benefits are that any capital gains that those shares would have accrued, they would not, if they were to, instead of, realizing them or cashing them, donate them to the charity, then they would receive the charitable tax receipt and they would be exempt from paying the capital gains tax on their increase.
Okay, I want to have two more questions on this, and then I have another one that just came in from Rowena, but you talked about kind of receiving these charitable gifts. And so a question came in is to how much say someone can have. So say they've made the decision that they'd like to be able to give to a charity, and they see something in terms of them leaving that legacy and that impact. Are they able to have a say in that discussion with you or with that person within the organization to say how they would like that to be used?
Yes, they absolutely can, and that's exactly why we like to be aware of the gift ahead of time, so that we can have that conversation with them. So it really reflects what they wanted to leave behind for the charity. And the other thing that we like to share with them is, for example, including a clause in the will, because as much as we'd love for that gift to go to their intended purpose, sometimes, we're hoping a great long period of time will go by before we actually receive the gift, and at which time the circumstances might have changed. So, if the gift was intended, for example, for hypertension research, because the family has a high propensity for hypertension, but 20 years from now, when we actually go to receive the gift, hypertension's been cured. It's no longer an issue. Then we'd like to be able to redirect that gift to somewhere that still honors that donor's wishes, but that is having the biggest impact. And I think really at the end of the day, that's what donors want. They just want to know that their gift is having an impact and is closely related to an area that, that was important to them.
Because we have Paul and Marilyn here, have you had that discussion, Paul and Marilyn? I mean, I know that there's the legacy gift that's coming, but has there been a discussion as to what you would see or where in the Heart Institute you would like to know that your impact is being made?
I think we've just left it to the big pot to be used at their discretion.
You guys are so easy.
It's a really good point, Lianne, because I agree with Selva. It's huge to have that conversation ahead of time and have the will reflect any particular provisions for programming or purpose, but to have a plan B. My wills, I cannot stress enough how much a plan B, how important it is to have, so that the gift doesn't fail, whether it's to the charity or whether it's to an individual. There should be a backup plan in place, because time does pass, and you can tell by your poll, not everybody updates their wills regularly, as Paul and Marilyn have been doing, but sometimes things get missed. And so having the backup plan at the time you're drafting originally is super helpful and ensures that a charity isn't spending money on lawyers to go and fight about whether or not what was said is what's supposed to happen. That's not a great way for lawyers to make money. Our goal is to draft a will that represents the client's wishes and accomplishes the goals that they wish to have accomplished as efficiently as possible.
Okay, I want to, because we've come in and I really want people to feel like we're getting to their questions. I'm going to leave this open, so I don't know who's going to jump in, but this is coming from Rowena. So how do you maximize the benefit of what you are giving to charity and to your family? My understanding is you can give up to 100% to charity the year you pass away.
100% of the charitable receipt can be used in the terminal return, provided the payment has been made. So sometimes there's a carry forward and a carry back. So again, working with the accountant is the best way to maximize any tax savings that are going to be had.
Okay, and I think we had someone, it's interesting with the bank accounts, but this is triggered. So Alex is asking, could you please, Heather, elaborate on the problems with a joint bank account or a joint title with an adult child?
Oh, yes. So it used to be the case that joint accounts would be presumed to pass by right of survivorship. But there has been a Court of Appeal case of long-standing now, so that an asset that is held on joint account with an adult child is presumed to be held, and you get very legalese here, on a resulting trust. So it is not presumed to pass by way of gift to the joint account holder, but the law presumes that the adult child is holding that asset in trust for the benefit of the entire estate to be distributed according to the person's will. So it is sometimes the case that clients will get advice to avoid probate. You should hold this asset jointly with one or more of your children. And probate is a different question. Probate is an application that an executor makes to court to prove a will to be able to conduct and administer the affairs of the estate. And third parties are assured that this is the last will and this is the person we should be dealing with. There is a fee associated with that. In this province, the fee after the first $50,000 is 1.5% of the value of the estate that passes under the will. And so if you can carve out assets of the estate by having a designated beneficiary, then the result is that there will be less probate fees paid. And so sometimes if the planning hasn't been wholesome, you are going to find assets that have been put into joint account, not because the joint account holder is intended to receive the asset to the exclusion of the other beneficiaries, but for the sole purpose of avoiding probate. Long answer to a short question.
It's a question though that I think has come up and people are looking for that answer. Now you have someone that's completely independent, but I have a question that came in from Olga, and she's saying, if you are single, have no properties, no life insurance, no kids, should one still have a will? So still working on getting permanent employment and paying off student loans, you know, where are they in this conversation and what should they be doing?
They should absolutely still have a will, because they still need somebody who is going to manage the estate on their passing. And the estate doesn't have to be an estate of assets. It could be an estate of debt. So it is very important that somebody is still in charge who can manage that. If you die either intestate or you die with a will and nobody who is named as the estate trustee is going to step up and actually do that job, because they don't have to just because they're named, then in theory, the public guardian and trustee for the province of Ontario would become responsible to administer the estate of the deceased person.
So really, this is about taking that responsibility for you, for your loved ones, for anyone, and that you have this ability to have this discussion. And then another one came in, and this one I think is going to go to you, Selva. What are the pros and cons of setting up a donor-advised fund versus a foundation to manage annual legacy donations? Do you need me to repeat that, Selva, or did you get that?
Repeat it again.
Okay, so this is from Lee. What are the pros and cons of setting up a donor-advised fund versus a foundation to manage annual legacy donations?
Okay, so I'll answer what I can, because this is a little more of a complicated question from my knowledge. I can tell you that the benefits of setting up a donor-advised fund is that you receive the charitable tax benefit associated with your gift pretty immediately, and yet you have the time and still the ability to direct that gift as you would like. It's hard for me to answer the question as it relates to how is it better than a foundation. Well, the foundation, there's a lot of legalities involved with that, and designations that would be more difficult to acquire, whereas the donor advised fund is more of a, you know, a straightforward setup. So I might look to Heather to maybe comment a bit on this, because yeah, that's a little beyond my
And I would look to my partner Andre, because he set up foundations. But yes, you've hit it, Selva. The donor advised fund is a less sophisticated way of giving, and a foundation requires CRA approval. There's a whole legal setup. You need a board. It's a lot more complicated, but it may make sense for a particular family. So again, there's not a one answer for everybody. It depends on what situation they find themselves in and what they're trying to achieve, and what assets they have to put towards it.
Speaking of assets, I had a quick question that came in after one of your answers, Heather, and this one I think is really poignant, because Leslie says, debt dies with the person. Isn't that right?
No, it's not right. It doesn't, you can't inherit debt, but you can have a bankrupt estate. And if anyone is named as executor and they're attempting to administer a bankrupt estate, then they must do so with the utmost of caution, because you can, if you mismanage it unintentionally and apply assets in an improper order to pay off creditors, then you as a estate trustee could become personally liable. So it's a very technical area.
So essentially, you've got to keep paying off those credit cards. Is that safe to say?
Unless you have your magic 8 ball that's going to tell you when you're going to die so you can use everything up until.
Yeah.
But yes, you can have a bankrupt estate just like you can have a bankrupt individual.
You know, we're hoping for the best. I know it's a difficult conversation to have. And of course, you know, I look at the health and prevention and trying to get people to live longer, healthier, more fulfilled lives is where I'd love to be able to take this conversation. And we're seeing that right now, like Paul and Marilyn, they're healthy, they're active. I know as a past patient for Paul, like there's an understanding, you know, that there's the Work of the Heart Institute, but in their scenario too, they've got shares, they've got a whole bunch of things. Do they continue to update? Like Paul and Marilyn, have you kind of come to the conclusion, like, I think we're good? Or is this something that you continue as, you know, life evolves and, you know, there's kids and the grandkids, like, how does this continue to evolve for you?
Well, I haven't mentioned it to Marilyn, but tonight's event is triggering me to say, I think we should go and have another review and do a few updates from the 1914 or the 2014 version.
Has been, but like, what was the trigger? You know, because there's other people that are sitting in on this conversation. You know, there's certain things, but can I ask you what might have been that trigger of, okay, let's do a little bit of an update?
Well, some of Heather's answers have raised a couple of questions in my thick head here. And so I just feel we should go back and take a look at what we did 6 years ago and exercise it again.
Well, Marilyn, you might be having a glass of wine after this, after we wrap up on the webinar tonight. A little bit of the change of the date night that you guys had originally planned. And Selva, do you deal with this? Like, do you, have you been at the other end, get calls or have people that call in to say, you know, this had been done, but we'd like to change, or we see something happening different?
Yes, absolutely. Paul and Marilyn are one of the people that have told us. But I mean, really, legacy gifts should really be as fluid and should change and be updated just as your will should. I mean, you know, you might find that your circumstances change throughout your lifetime and that you might need a little more and you're unable to give what you would have hoped to give to a charity, and that's okay. Or you may find that you're able to give a little more, you know, and that's great too. So you should really be revisiting at the same time that you're revisiting your will. You want to be revisiting your charitable giving and see, you know, what's realistic for me, you know, at this stage.
So can I ask you, what do you enjoy most about this role? You know, sometimes it's a difficult topic, and yet at the other end, there's so much positivity and certain things that come out of it. I know it's a personal question, but like, what is it for you?
You're asking?
I was asking.
Oh, sorry.
Yeah, Selva, yeah.
Honestly, what I enjoy most about this role is the stories. I don't know if it's because I'm also a history major. I don't know. But I love hearing the stories, the individuals, why they've chosen to give, what their relationship is. And oftentimes I'm also not hearing it from the individuals. Sadly, I'm hearing it from the family members, but I find that kind of nice too. You know, they tell us a bit about their family member and why it was important to them. And sometimes it has nothing really to do with the gift, just about who that person was, you know, that tells us a little more about why they left the gift too. So yeah, it's the stories. I enjoy the stories. Yeah.
Well, Paul and Marilyn have a great story, but I'm glad that we know the story, that we could hear it, you know, from them. Like Paul and Marilyn, was it important to share it and to have it out in the open with the family, with the organization, so that the other organizations also, I know we benefit, but there's others that conversation was had?
Well, I think so. Maybe I should ask Marilyn how she feels about it.
About what?
About sharing it with the organizations.
I'm happy with that. I'm fine. It's I'm proud of how Paul has handled it all, recovering from the heart attack and then wanting to pay back. And we certainly feel that that's a positive response. So
Just of interest to your, there was an article in your magazine about 2 years ago on our story, but the heart attack I had was one that if I hadn't gotten to the Heart Institute as quickly as I did, I was gone. And I walked 18 holes of golf 2 weeks later.
It's amazing. And I think you get a sense of that every day. Every time you're out walking a golf course, that you're there to be able to do it.
Well, the golf course is closed for the winter.
I think you had a pretty good season, Paul. I think every golfer had the best season ever, unfortunately, with these circumstances.
That's true.
Okay. It is, yeah. A couple more questions came in, and so we have a little bit more time, so I thought I'd get to them right now. This one came in from Leslie saying, all my relatives are older than me, so how should I pick an executor? And can or should a charitable institution be an executor? That's an interesting question right there. Heather, I'll think of that one for you.
Sure. I'm seeing more and more trust companies appointed as the role of estate trustee. I have never seen a charity, and I don't expect they would take that on, but Selva might be able to answer that one more clearly than I. Just because a relative is older doesn't mean that either going to die before you or that they're not going to be able to do it. But it is certainly a consideration, which goes back to the plan B. So sometimes my clients will appoint a relative or a family member, close family member first, and then a trust company as a backup. That way, if the family member is there, that's great. Alternatively, you can appoint a trust company and have the family member as an advisor. And then you've got the family connection, but they're not going to feel burdened with the administration. So one of the things that an executor, the only thing the executor cannot do really is delegate decision-making. They can delegate all of the administrative tasks they wish. So even if you appoint a family member and they feel overwhelmed by all the tasks, they can hire professional help to carry out the administration.
So there's administration, there's numbers, there's percentages. And so I had a question that came in about that, about percentages, about amounts. And so is it better to specify amounts or a percentage in the bequest?
Good question.
So,
Not a good question, Paul, yeah?
yeah, Paul's structure sounded very good and something that we commonly employ. So the risk in drafting a will is that if you are too specific, you may end up with an intestacy. So people say, well, what's that? I have a will. Well, if you have assets left over after the application of all of the provisions in the will, and you don't have any instruction as to what to do with those leftover assets, then yes, you do have an intestacy. And then the Succession Law Reform Act kicks in to say who takes what's left over. So Paul and Marilyn's method sounds very ideal in that there are some specific bequests, which can be percentages or fixed amounts. And then we talk about shares, and that's the residue. So that gives you the flexibility of making sure that perhaps your family members have a fixed amount. And if there's nothing left after that, well, there's nothing left after that. But if there is something left after those fixed amounts, then we can talk about creating as many shares as will give effect to the following distribution. And that way you can keep the ratio between the family members and or the respective charities and ensure that there's nothing left over. So you don't have to parse it out to that last penny, because my magic 8-ball doesn't do that.
That's really interesting though, that actually seems to make the most sense. If I'm, out of a lot of the stuff that you said, it kind of like you take care of the family of everything that you were wanting. And then there's that percentage that's left afterwards. That's able to be distributed. And a question that came in from Wesley to say, is there a simple standard? Is there a simple standard will that stands the test of time? Is there a magic piece of paper that will, stand the test of time for all of this?
That's a really interesting question. So I will tell you about my favorite case, which is the tractor case out of Saskatchewan. So a gentleman farmer told his wife he was going to plow the back 40, not to expect him until late after dinner. So nobody went looking for him. He had a terrible accident. He got pinned under the tractor, and story has it, he pulled out his jackknife and carved into the fender of the tractor. "If I die in this mess, I leave it all to the wife." The next morning, when daylight hit, he was discovered, and as they were hooking up the other tractor, I gather, to pull out the one that was embedded in the ground and had him pinned, a kid saw the scratching in the fender. The fender was cut out, was submitted to the probate court in Rosetown, I believe, and now sits in the Saskatchewan Law Library. So that's a pretty basic will. There is no magic. There are certain things that must be in a will. But if fender's been probated, I have probated the charities that send you these lovely little notepads from the desk of. You know, you get those every once in a while after you've made a donation. I had a client whose husband went overseas and had left a note on the notepad about his testamentary intention in his own handwriting, signed and dated at the bottom. That's what we would call a holographic will. So even though it was on a little piece of notepad, you know, much like this, I submitted that to the probate court in Ottawa, and we got probate back. So is there magic to a will? There are certainly problems that you can come across if you don't do it right. So a holograph will versus a will prepared by a lawyer or using a will kit, they all have potential for issues. So it's really important that you understand what's in your will, you review it regularly, and you're careful about its preparation.
I think that's one thing I've learned the most is that it's living and it can be fluid, right? These are words that I'm hearing from you and from Selva, and to understand that Paul and Marilyn knew that as well and continue to. It was living. It needed to change as the lives and everything changed. And there's a lot of information that's come at you tonight, and I see that happening. So, and I think I mentioned it right off the top, Selva. There's a lot of paperwork that I see you do a lot of the time, and so I think sometimes people are just looking like, what exactly do I need? What are some of the guidelines? And I know that you've been preparing an enormous amount of documentation. So what would people be getting? What is it that they should be looking for, checking off in boxes, asking for from somebody that's helping them to move forward with all of this?
Well, it helps when they're considering a charitable gift. It certainly helps to have information on the types of gifts and maybe some of the tax benefits associated with those. When they're considering how to include those gifts in their will, kind of the clauses, how to include them in their will, and to talk about, the direction and whatnot. And we can provide them with a documentation that tells them about, what our priorities are, for example, at this time, that can help them sort of direct or focus their giving, a little more. But a lot of the other information that's that really makes up the bulk of the will and whatnot, I mean, that's information that their lawyer can provide, that is best to provide, really.
I'm going to do a quick roundtable around everyone, kind of some last final thoughts. So Paul and Marilyn, if you don't mind, your final thoughts on being involved in the webinar, and why did you want to be able to share your story so that others, had a little bit more knowledge, a little bit more understanding moving forward?
Well, we wanted to share it. We wanted to share it because you asked us to, and I think we think it's very important that everybody has a will, and where you're in a position where you can give some benefit to some charities in the process. I think that should be done. There's no point leaving so much to relatives that don't need it, but sharing it around to families who can use it and make sure your children and grandchildren are appropriately looked after is important. So that's what we've done.
Well put.
Absolutely. Thank you to Paul and Marilyn. And I'm so glad he's in great health and walking the golf course and had a ton of rounds to get in this summer. Heather, some final thoughts. What would you like for people to really take from this to understand, the importance? I know there's things that people need to know. They like checklists, and there's common mistakes. So if you can kind of round it up for us really quick as to what should people take from this?
Find your advisor, make a will. It's the kindest thing you can do for your family. It's as simple as that. the person who's making the will, if they know the end is near, it gives them great peace of mind to know that their affairs are in order. And it has been an honor for me to work with so many of my clients who know the end is really near, and but have made the time to make it a priority, even at the very end, to get it done and done right, so they can pass knowing their family is in good shape. So that's important.
I think I remember, and I think a lot of people know my association with the Heart Institute, having lost my dad at a very young age. There's so many things that are occurring. There's so much grief that a family is going through. To take one less pressure, one less decision in the most difficult of times, this is almost the gift that you are giving to your family, is to take that burden off of them.
Yes.
Really appreciate you had a lot of tough questions there, Heather, and there's a reason why there's like this own entity of like the taxes and the benefits and so forth. And Selva, this is your everyday. This is your everyday at the Heart Institute, at the foundation. And so this is about passing on as much information as possible. And I know, what can people expect? You have a ton of things that are going to be coming out for people once this webinar wraps up.
Yeah, so first of all, thank you to everyone who joined. It's great. We are going to follow up with all the attendees, and we're going to send them a package that will kind of include some information that Heather's put together that will speak to a lot of the questions that we had tonight and some of the conversations that we had. And from the charitable giving side, we are also including, the different types of gifts and some of the tax benefits associated with that. So we're going to be packaging that and sending that off to all of the attendees before the end of the week. Mm-hmm.
Which is great new information to have, because there's so many different ways and opportunities to have those charitable gifts really make an impact, and also find some advantages for yourself. And especially, I know, because we just were talking about this at the foundation, like the next couple of weeks are really busy because there's so many tax advantages right now prior to the end of the year, right? And it's the gift that keeps giving on this one. That's pretty right?
That's right.
So thank you so much. Somebody wanted to repeat. I think Angela just said that. Heather Austin-Skaret, that is the name of the lawyer that was joining us tonight. I'm not sure, Heather, I think you might be getting some additional phone calls, and we do hope that Selva gets some additional phone calls with some of the families that are looking to be able to leave those legacy gifts and find something that is kind of impactful for them, and to leave that impact and that legacy gift. So thank you to Selva, whose amazing work at the foundation happens every day. So glad that Paul and Marilyn were able to join us, even though they said they joined us because we would ask them to, but they were so giving and so absolutely, we're totally on board. So thank you so much to Paul and Marilyn, and of course, Heather, once again, thank you for the knowledge and for some really clear indication and answers that a lot of the people were looking at. I think I actually got to everyone. So I'm kind of going through, and I think I got through the whole list, and there were some great questions. So thank you so much. And if you missed this, or if you know someone who's going to benefit from this, we will have a taping, a recording of this that we will be posting. So if you want to go back over something, if there's something you missed, or you want to look at that answer again, we will be posting this webinar to our website as well. Thank you so much to everyone who joined. Thanks to Chris, who was behind the scenes working all of the technical aspects, so it didn't look like we were all on a Zoom screen for you tonight. And be healthy, stay safe. We're in very interesting times, and this was a really interesting conversation to have. So stay healthy, stay safe, and look for this online if you need any additional questions. Thank you so much.
Thank you. Good job.
Good job.
Good job.